Good evening, everyone. I am Siaman Rajput, moderator of this webinar. We are delighted to welcome you all in this webinar being organized by the Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICAI, which is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value by combining analytical foresight with commercial acumen. The core area of this committee is to serve the multifunctional task of analysis, spreading knowledge, and providing inputs to regulations and policy formulations to develop and publish technical guidance and background materials. Also, this committee works on creating awareness of all professional opportunities for chartered accountants in commercial law, economic advisory, and NPO cooperatives. It is my privilege to introduce our eminent speaker for today, Mr. Kunal Sir. Sir is a company secretary and a lawyer by profession. He qualified his CS with All India Rank 24. He is the founder and managing partner of White Collar Legal LLP, standing a leading multi-state corporate law firm. In addition to his legal practice, he is even a professor at premier institutions such as IIM Ahmedabad, Flame University, and SIBM, where he imparts knowledge on legal aspects of business, innovation, and IP laws. His notable credentials include being a TEDx speaker, a published author, and former ambassador for Ministry of Youth Affairs and Sports. Furthermore, he has played significant role in facilitating private equity fundraising for various startups. We are honored to have you here, sir.
Thank you. It's a pleasure being here. Shall I start or is there a welcome? Okay. So it's always beautiful to speak on this topic. I can give a 3-hour session on this in my sleep as well. I've spoken about it so many times. But before I go into it, I want to give you some context. So intellectual property was not my first area of practice. Like many of you who have joined, my traditional area of practice was corporate law, the Companies Act. And when I started my practice in 2013, the Companies Act had completely gone through a change and sort of come back into resurrection in a new way. And mastering that, for some time, it took a few years. After that, when we came, let's say around 2015-16, the IBC law was brought, the GST law was brought. I mean, it was as if the government wants to give us, a challenge every few years in terms of mastering laws, mastering, different practice areas. Intellectual property, I think I started as a very side practice when I initially looked at it, where some trademark filings used to happen, 1 or 2 copyright filings used to happen, and I'm talking about monthly. So it was not a hot area that time. But what I've seen in the last, I would say 7 years or so, that it has really picked up. And why it has picked up is, I always say that there comes a sweet spot when all the ecosystem comes together. For example, Jeff Bezos has once said that for Amazon to be successful, we needed to have good internet connection. We needed to have PCs with everybody. We needed to have software that is easily. We needed to have good logistics that once you order from warehouse to your house, the product can travel. And because this ecosystem was well built, it was well oiled, it was a beautiful working machine, was Amazon successful. So today, if you see, a lot of Indian companies which were earlier into trading, manufacturing, B2B, have suddenly gotten into making brands of their own. We see rise of brands which are completely D2C. We see rise of companies which are tech companies. I call them knowledge heavy asset light companies. There are so many examples of them. I will talk to you about in the presentation. So now we are at an inflection point where the business models of today are very different from the business models of, let's say, 20 years back or even 15 years back. Today I was reading about a quote from one of the hedge fund managers that the next milestone is for a single person $1 billion company, and that single person $1 billion company is being possible only because of the use of tech, use of AI, use of scale, and use of all these algorithms which are new. So with that context, let me present my presentation and get started on the topic. So while we keep focusing on our traditional practice, I will try to make a case today as to why exploring IP is sort of a complementary practice for all of us. Right. So if you see the world map, it paints a very interesting picture, and you understand that the most innovative countries are not countries like the USA or China or any other rich countries. So innovation is never a function of money. It is never a function of capital. Innovation has always been a function of culture. And as you know, intellectual property is coming up with new things, coming up with inventive things, things that save time, things that bring more value, things that make things faster, cheaper, etc. And therefore, this map shows you that South Korea is doing fantastic when it comes to innovation. Israel is doing amazing when it comes to innovation, especially defense technologies, and so on. So what I want to tell you is, where does India sit in all of this? And I would say in India, IP was never a core subject. It was never taught in a practical sense. And hence, when I'm visiting the premier institutes, be it the IIT Bombay or be it VIT Vellore, I notice that the talk around innovation, around invention, around filing patents is not very mainstream. And that has got to change, because we are a very innovative country, but none of our innovations are actually being registered. They're not being pursued. They're not being drafted properly. And hence, all that intellectual output is not being captured in the right way. And since we are professionals who work with the founders, who work with these startup guys and the large company owners, it is our duty to somewhere advise them properly as to how it goes. And I personally feel, given the number of filings that I've been tracking since, like I said, 5 to 7 years, it's growing exponentially. The couple of trademark and copyright applications we used to file, they have gone exponentially higher. Today, I am managing a portfolio of around 3,000 trademarks, and that in itself has become my core practice area, along with my traditional. So whenever you look at your practice from a distance, you can easily observe the sunrise areas versus sunset areas. So I look at IP as a sunrise area now. And in this presentation today, I will focus largely on trademarks, copyrights, designs, and less on patents. Because for patents, you need that technical expertise, that science background, understanding of. So I will not go into those aspects, but I'll theoretically, of course, explain it to you. So before you go into the topic, another myth that people have is that intellectual property is for very radical things, very disruptive things. It is for somebody, who replaces a candle with a bulb, somebody who replaces a horse with a carriage or a horse with a car. It has to be completely new, 0 to 1. I completely disagree. And innovation can be in the smallest of the features, it can be in the smallest of the increments. And therefore, I always say innovation and invention is not always disruptive, it is always incremental. Like the image that you see, you don't jump from the 1900 to 2016 you go through iterations, and every iteration is a new patent in itself, is a new intellectual property in itself. Here, I want to give you an example of so many software companies I work with who, although the entire software might not be novel, but some features of that software become novel. For example, I was working with a client who was from Bangalore, who in 2014 had come out with a feature known as raise your hand feature, which is so common today. And that feature he had created because he was teaching children in remote parts of India. We patented that software feature. But when later on COVID happened many years later, remember March 24, 2020, all these large companies came into India. They all had to make a deal with this Bangalore company to get a license to use this raise your hand feature. Now, the license fee that this company earns through the giving of this technology, giving of this small feature is more than its turnover. So, like, models like this where founders look at gaps in the market, create prototypes, create algorithms to fulfill those gaps, and then sell it to the large companies who want to acquire the technology from them. So this is the norm of the day, and that's why I said knowledge heavy and asset light. So this is a, I mean, interesting statistic. Again, I have to update it. Become a little old now. But if you look at it, you will notice, except I think Baiju and Paytm, which have gone down due to different issues, governance issues, financial issues, you will notice others are going strength to strength. For example, Zomato now is a listed company, profitable company. The acquisitions it has made, like Blinkit, District, they are doing very well. And the beautiful thing about these is no physical assets. So typically, when you are valuing something at fair value or valuing shares at a discounted cash flow, similarly, IP valuation becomes a crucial game on which investors love to invest in companies and ascribe a separate set of value for its IP. And this story is not just in India, but everywhere in the world, you will notice that companies are becoming IP heavy and asset light. The biggest company in the world in terms of cash flow, Apple, has all its intellectual property stored in its headquarters in California. Where does it get its products manufactured? It gets it in China, it gets it in Taiwan, it gets it in India, in Chennai, along with the Tata Wistron partnership. If you look at Nike, which is the largest shoemaker, very, very high value, monopolistic position. Where do they hold their IP? They hold all their IP in the US head office. Where do they manufacture the product? They manufacture it in Vietnam. They manufacture it in Bangladesh. So similarly, if you notice, most companies, they will always and always, let's take the luxury fashion brand Louis Vuitton. Louis Vuitton sells one bag for 6 lakh rupees, 10 lakh rupees, and they have had a fantastic year in India. Now, where do they make the bags? They make the bags in Bangladesh, right? So you make it where it is cheap, where labor is cheap, electricity is cheap, taxes are low, and you retain the IP with you. And the whole value is in the IP. Today, if you see the tariff war that we are part of due to Mr. Trump's announcement a few days back last week, you will notice that some Chinese manufacturers have come out in the open and have revealed their margins, that a bag that they are selling or making for, say, $50, $60 is being sold in the US, in Europe at $25,000, $30,000. So look at the markup. It is insane. And the entire markup is for the brand, nothing else. The brand, the quality, the product, etc. Similarly, I was today, when I was watching the news, I saw that Mercedes had its best year in India. Lamborghini sold over 100 units in India. Porsche sold over 1,000 units in India. So Indians are getting wealthy. Indians are having great purchasing power, and they're investing a lot in brands. In fact, if you look at companies like Boat, right, which is Aman Gupta's company, one of the co-founders, it's nothing but a brand play. The product is not a unique product. It is a commoditized product. You bring it here, you white label it, and you sell it in front. But why are people buying it? It's because of the brand. I know so many brands, I will not take their names, but all their products come from a single factory and more or less the same recipe. They are just putting different labels and it goes out to the market, be it a cosmetic product, be it a nutraceutical product. So I think you get the hint of where I'm going. So this same trend is going on in the entire world. where companies are focusing on protecting whatever unique things that they do and getting it done somewhere else. So another myth people have is inventions are done by scientists. They are done by people who are crazy. They're done by people who are, like in a Three Idiots movie. It's done by people like Rancho, very unique thinking, very creative people. But I want to break that and talk to you about Hazik. Hazik met me when he was 10 years old. He designed this ship, as you can see, the ship that cleans the oceans, cleans the water, and he designed this for a school competition. But when we met, we filed for a patent, etc., the patent got commercialized very fast because the technology was so easy, so simple to use. And now he's commercialized it. He's become a good commercial success. He's given a TED talk in New York. He's become a big celebrity now, all at the age of 10, 11. So today's talk, when I'm talking to you, I'm not just talking it from a practice area edition, but also as an inventor. All of us lock ourselves in identities. We say that I am a lawyer, I'm a chartered accountant, I am a doctor, I'm an architect, and then we are bound by that identity. We are caged by that identity. I wish we are able to break through that and also think ourselves as inventors. Of course, a practice area also I'll talk about, but in a broader context. So Hazik's invention, which was made for a school, now has commercial applications. He's supplying almost 400, 500 pieces of this technology to the merchant navy and to many other private organizations, all at the age of 10, 11. That's all. So in my line of work, I get to talk, interact, and work with very interesting people. Given that our session is a short session today, I won't go in all of them, but let me try and pick cases. This is a good case that you can see, the Good Dot company, who wanted to make vegetarian meat or meat from vegetable waste or meat using a new technology, and the technology is now licensed everywhere. So again, the same model: you make something, you perfect it, and then you scale it, like McDonald's, like KFC, and all these food brands who are able to scale a very simple product like a burger. And here, when I talk about technology, people often do the mistake of assuming that technology always means software. I would draw your attention to a fantastic company in Pune called Bajaj, one of the largest automotive companies when it comes to two-wheelers, who come out with amazing technologies like the DTSI engine, the different valve technologies. All these are patented. And when Bajaj, if you see how they are growing in Africa, how they are going in other South Asian markets, it's just phenomenal. So technology need not be only tech or software, it can be in all these sectors. Imagine, there are clients, I have a client of mine who's trying to do what McDonald's did for South Indian food. He's trying to bring standardization. He's trying to bring SOPs. He's trying to create franchise-based model so that he can open 100 stores. In fact, one of my clients who's based out of Gujarat, out of Navsari, runs a very interesting chain where his two or three products have scaled to over 100 outlets. It's lovely to see that. And this was not the case earlier. Whenever I traveled abroad, it was very rare to find an Indian brand. But now, if you go, you can see Haldiram, you can see Cafe Coffee Day, you can see so many Indian brands. Jaguar, Land Rover is seen so many places. So it's wonderful to see that Indians and Indian businessmen, Indian entrepreneurs are focusing so much on protecting their IP. Now, this is a question I always ask, that, whether you think Ford is a success or a failure in India. And a lot of people say, no, they are a failure. They left India. They're not able to sell cars here. But I always say that's not the case. Ford invented the assembly line system. They invented many parts of automobile production, mass production. And till today, anybody uses their technology, they get a fantastic license fee out of it. So today their entire model is protecting the license fee and not really selling cars, selling spare parts. That is like a side business. The main source of revenue, the primary source of revenue, is license of intellectual property. Here I would like to take the example of Fiat also. People think Fiat is a failure company in India. Absolutely not. If you look at all the top selling diesel SUVs in India, be it MG Hector, be it Tata Harrier, be it Jeep Compass, be it Tata Safari, all these cars are using the Jeep engine, the Interjet, whatever engine, 1.3, 1.5 liter, and they're doing so well, right? So Fiat just went from going B2C to, and they became a B2B company. Again, what are they doing? They're licensing their technology to produce diesel engines because India does not have the R&D capability, but we are building now, especially if you look at Mahindra, such fantastic technology in terms of EV cars. Go Tata and Mahindra actually. So again, I have multiple examples. I'll skip them in the interest of time. Now, I think I want to spend some time here and explain to you that earlier, if you remember, whenever we talked about artists, I'm talking about artists in every field. For example, let's take Lata Mangeshkar in the field of music. Let's take R.K. Lakshman in the field of journalism, or let's take Satyajit Ray in the film, in the field of filmmaking. These are three legendary figures in their respective areas, but you will notice that they were not commercially very successful. In fact, I remember looking at Satyajit Ray's Oscar winning speech, and he basically says, he's not got his due. He basically says that, commercially could not invest in good assets, good house, etc. R.K. Lakshman had to come back from Mumbai to Pune because commercially it was not viable. Lata Mangeshkar, I read that she was hospitalized before passing away, and her wealth was estimated to be so many crores, which was surprising to me. I thought she would have much more. And that was because Indian artists never realized the value of IP. Indian artists always took an upfront payment and never took a royalty deal. And that is hurting them now. But today, the goal has completely changed. You will look at new artists like Anuv Jain, you will look at, oh, I mean, artists like Bacha who are not as good as Lata Mangeshkar, but they are doing much better than them economically because people like Bhushan Kumar, people like T Series, they are helping them collect so much revenue. Even government agencies like IPRS Society, Intellectual Property Rights Society, helps music composers, helps lyricists, and helps such other people in the industry earn their whatever share when people listen to their music, when they watch their films, and so on. This model has primarily come from Disney, where Disney does this on a global scale. And that is why people like Michael Jackson are still doing so well despite passing away many years ago. The organization, the trust still gets very good money from Michael Jackson's music because people still listen to it. People still love his music. So today, if you notice, piracy has gone down considerably. People are consuming their content through paid sources like Spotify, Apple Music, Ghana, YouTube, and therefore the artists are earning well. They are able to monetize their content in a better way, and this is only going to grow up. I know so many influencers, they are my clients. And whenever I talk to them, I'm shocked at how much revenue they're able to generate per video. How much brands are paying them per integration. It's fantastic. And why are they doing that? Because it's their own IP. The characters they create, the stories they create. One of my favorite is the TVF guys. They do the best, I would say. So I think with that context, I come into the topic of intellectual property. And uh, now I'll try to be more practical and try to focus on the topic of how to add this as a practice area. Yeah. So first, you need to understand this difference between uh, is there a difference between innovation and invention? And the simple answer is yes. Innovation is when you are adding on top of something existing, and invention is when you invent from zero. Now, is intellectual property applicable for both? The answer is yes. It is applicable for both. People have a wrong assumption that is only applicable for invention, but that's not the case. As long as, so you know how to test this. Who will tell you whether you are eligible to file an IP or not? It is a novelty search, a search where your invention is compared with all the existing inventions, and a report is given to you saying that your invention is so many percentage original. And as long as you are substantially original, more than 75% original, you are good. So that is an interesting, point I would like to make. Now, intellectual is fine. We understand, right? You cannot force this. You can't work hard. It is a product of your intellect. But why is it called property? So the answer is simple, because it satisfies all the features of being a property. Can you buy it? Yes. Can you sell it? Yes. Can you rent it out? Yes. Can you give it to your grandchildren? Yes. Can you value it? Yes. Can you make money from it? Yes. So if you see, it satisfies all the features. At the same time, it it's like goodwill. You cannot touch and feel it. But just like goodwill can be valued, so can IP be valued. And therefore, why do people do intellectual property? Why is it causing so much, so much practice scope? Is these reasons. Because companies get a higher valuation. Because whenever you spend on IP, it shows as an expense on your P&L. But where does IP sit? It sits on your asset side. It's an asset. The patent is an asset. The trademark is an asset. The copyright of your music is an asset. Then it creates an entry barrier. Others can't copy your work. Others can't copy your invention. Imagine Serum Institute in India, the Poonawalla group, spent so much money coming out with a vaccine, and some other company just taking it to the lab, reverse engineering it, and finding out how it was made. What happens to all their efforts? It goes waste. So law creates an entry barrier for you if you have a patent, trademark, copyright, or a design. It avoids freeloaders. They have to, anybody wants to use your technology, they have to license it from you. You have to authorize them, you have to charge them a royalty fee, and so on. Then it avoids infringement, like the same logic. It gives you an incentive to invent. Any person who's putting in time, money, effort, experimentation, and coming out with a fantastic innovation, he needs to be rewarded. All the money and time and effort he has put in, all that he needs to recover back. And that is why intellectual property gives you a beautiful time period ranging from 10 years to a lifetime plus 60 years to recover and make some money. That is an incentive as an inventor I get if I'm filing for intellectual property. And of course, whatever high capex you have done in coming out with an invention, you have an opportunity to recover that. And lastly, I would say all these reasons are fine. What is a practical reason why you require IP? And the practical reason is because it has become mandatory. You want to sell on e-commerce, you need a trademark certificate. You want to apply as a startup, as an innovative startup, you have to show your provisional patent filing, your patent publication filing. So everywhere you go, the government through policy, or the industry through a mandate is making all this mandatory. That is why you won't believe, but one of the quickest growing areas for me, I have a branch in Surat also. The quickest growing area for me in Surat. It Pune, Mumbai, of course, Bangalore definitely, Chennai definitely. But I'm surprised at how many trademarks or how many IP applications I'm doing from Surat. Why? Because Surat people are all selling online, and Amazon and Flipkart have made it mandatory. They are selling and giving their product internationally. Again, that requires a patent if you're claiming innovation. So all that, the system is driving them to get it registered. So I always say that my business comes from the government. The government is my salesperson in a way. So the major branches, if you so to speak, are these branches: patents for products and processes, and for utilities. I'm talking nationally and internationally because sitting in Pune, I can file anywhere in the world. I can do anywhere in the world because India is a part of the PCT, the Patent Cooperation Treaty. India is a part of the TRIPS agreement. We are part of the Madrid Protocol, the Brussels Protocol, or I will talk about them later today. But we have been part of all these treaties, which make IP laws a universal subject. And I think most of us struggle on this, that whatever we study has domestic applications, not international, but IP is not like that. You can file international applications all the time. Copyright is for artistic work such as paintings, sculptures, musics, scripts of a film, all of that is copyright. It's basically a right to copy. It also includes derivative works like Harry Potter is a copyright. And if you can create a film out of it, you can create a t-shirt out of it, you can create merchandise out of it, all that becomes IP. One good IP is the Marvel's studios, the DC studios, where I've seen youngsters, I'm also young, but I've seen teenagers, I would say, wearing these t-shirts with, their favorite Avengers or whatever. All that is IP. Trademarks are interesting, right? The name, the logo, the tagline, the sound, like Britannia sound, Paytm sound, and even smell has been trademarked. In fact, we also trademark the look and feel. So for the clients who are into a franchisee business, especially I have a client who's a restaurant who was a very unique restaurant concept. So we have also registered their look and feel, so that anybody who takes their franchisee and who does not renew the franchisee, they have to change the look and feel completely, right? So that gives us a lot of protection. Designs are, anything that is has a mold, which a mold, a sacha as they call it, which you can create multiple pieces out of. So as companies follow a design theme, as companies follow a design philosophy, they can also protect the look and feel of their products. That's why you will see that a Bisleri bottle looks like this, an Apple camera placement it looks like that. These are all design philosophies. Then we come to geographical indications, where products get their value from the geography they come from. Like Ratnagiri mangoes are so popular, Kashmiri apples are so popular, Nagpur oranges are so popular. Now, coming to the non-food product, you will see Kolhapuri chappal, silk from Kanchipuram. So all these are called as geographical indications. Mahabaleshwar strawberry, another example. So this can also become an IP. It gives the farmers and the people of that area a better price. It opens up the export market for them. So it's net to net very, very productive for them commercially. Then we come to trade secret and confidential information, which people try to protect through NDAs, NCNDAs, keeping the formula as a top secret, like Coca-Cola has done for many years, like KFC has done, that they don't file a patent, but they keep a trade secret. Why do they do that? Because they know that a patent will expire in 10, 20, 30 years, but their product will go on for a long time. For example, Coca-Cola is going on since 1880, 1890. So it's been more than 100 years, 150 years. So imagine if they had filed the patent, they had to disclose the entire formula and in which proportion which ingredient goes. And last is plant varieties. Plant varieties are typically done by people who are into agriculture or people who are getting benefited from agriculture. To give you an example, I have a client in Mangalore who's making seedless fruits. I have another client who's growing vegetables of different colors. I have clients who are growing lot of vegetable in a very small piece of land. All these are unique plant varieties. These are unique inventions in the agrarian sector. Now, you and I, we live in cities and we are living comfortably. We don't realize that almost 60-65% of India is an agricultural and agrarian society. And hence, for them, this becomes crucial when it comes to registration, good farming practices, and good agricultural methods. So coming to the fundamentals now, fundamentals are the core concepts which apply to all kinds of IP, and they apply to all kinds of examples that I discussed. So the first fundamental is that IP is a negative right. It is not like a passport which gives you the positive right to travel, or a driving license which gives you a positive right to drive, or a voter ID which gives you a positive right to vote. This, when you get a patent certificate or a trademark certificate or a copyright, whatever certificate you get, you don't get a positive right. You get a negative right where you can exclude others from using it. So I always say filing and registering a trademark is step one. Then finding a person who's using your trademark or your patent is step two. Sending them a notice, cease and desist, getting into a negotiation, getting into a commercial arrangement, getting that monetary value for your client, that is step three and step four. So it's a long game and it's a strategic game and it has to be played accordingly. Second is IP can only be done for things that are, useful in nature. It can't be done for anything which does not serve the society. Again, this is a test that the office will see, the patent office, the design office will see. It has to be something that is not published, something that's new, something that's universal. Now, this is a very interesting concept. The next concept is that when it comes to trademarks and copyrights, it is the person who uses that first or publishes that first is the owner, not the person who files first. But when it comes to patents and designs, it is exactly reverse. The inventor who invents first is not the person who owns it, but a person who files first. That is why we say that when it comes to IP, if you snooze, you lose, right? So you have to be quick in applying, you have to be quick in filing. Otherwise, if somebody beats you to it, you can't claim that, oh, I have invented it before you. You can't claim that. So it's very interesting to understand prior art and first filer, prior art for trademark and copyright, and first filer for patents and designs. Then we come to the fundamental principle of authorship. Author is the person who thinks of the idea. Author is the person who conceives of the idea. And in the intellectual property world, author is more important than the executor. So if I think of a unique chair, if I think of a unique sofa, and I give it to the carpenter to execute it, the carpenter does not become the owner of the IP. I still remain as the owner, as the author. Now, my a question that typically comes when I'm taking an in-person session is that if I'm working for a company or if I'm a full-time student in a university, do I become the author? The answer is you might become the author because you created the invention, but the right to economically exploit your invention will be with your company, will be with your university. And therefore, I always say that look at the contract properly. What does it say? Work product, if created, will belong to whom? What is the ratio? So, all of these nuances is something that clients will come to you and you should be in a position to advise them correctly. Then we come to the logic of jurisdiction. Please understand intellectual property when you file is limited to country to country. Of course, you can file it in multiple countries also. You can file it for the whole world also. But the fees, the way each country will scrutinize your application, that changes. So you have to be mindful of that. There are certain cases where IP is licensed for public use at a cheap rate. For example, vaccines. During COVID, the government set a maximum price for the vaccines because it was a public emergency. If we are at a war with any country, all the defense IP will be suspended till the war is over because it is in national interest. So all these are fundamentals. The last fundamental I want you to remember is the fundamental of provisional versus final, which basically means that IP registration does not require a working prototype. As long as you're able to explain what the invention is and how it works, that's it. But the government gives you a time frame of 1 year, 2 year to actually create the prototype and submit it. And I think a lot of people have taken advantage of this law. And whenever they get a good concept in their heads, they immediately put it down, register it, and wait. And many people, just through this blocking exercise, have made a lot of money where the larger company has come and acquired their concept. They have come and acquired their business models. And lastly, IP is based on classes, it's based on claims, and hence you have to be very careful as to where you register, under what class you register, whether that aligns with the business objectives of the client or not. So I would say, just like me, who had started with one application, three applications, 10 applications a month, to now handling about 3,500 applications, it's a journey. And as you do one, two, three applications, there's a learning curve. You will slowly pick it up. I'm glad I did that because today, when I see that the traditional practice is maybe not suiting or not growing or whatever, the new age areas are growing very well, be it IP, be it IBC, or be it any other new age area. Now, Coming to what is a practice scope? So I would say the practice scope starts from doing a public search, finding out the originality, whether something is registrable or not, filing that application, and then after filing, the applications usually get an objection under Section 9, absolute ground, or Section 11, relative grounds. Then filing oppositions, filing replies to oppositions. There is a lot of litigation that happens in terms of injunctions, infringement, passing off cases, for which I regularly go to the High Court and the lower courts. IP valuation is a very good exercise, which is a part of all startup fundraising rounds. A lot of transactional document is done when IP is transferred from one person to the other. It's called an IP assignment document, and there is a lot of royalty documents, a lot of license fee documents. So all this is just not applicable for trademarks, but it is applicable for copyrights, it's applicable for patents, and it is applicable for overall all kinds of IP. So it's a very beautiful practice area, and it's a growing practice area. The need for these services is skyrocketing, and the number of people who can serve are very few. We are very happy if more people enter this, so that the field grows more, people get better services, and all of us who are already sitting with a client base, all of us who are sitting with an experience, this also becomes a good avenue that is refreshing. Because I'm sure some of you might be also, it gets monotonous doing the traditional audit, accounting, bookkeeping, and that area of practice. So I say this is a very good, refreshing addition to your practice as a complementary unit. So this is the treaties that I was talking to you about, which India is a part of, which makes the IP law sort of uniform in every place. So as you can see, I have also listed down the name of the IP for which the treaty was done. Like the Paris Treaty was for industrial IP, the Madrid Protocol was for international trademark filing, and so on. For those who really want to dive deeper into this topic, understand practice areas, get formats, understand more in terms of case studies, more than what I shared today, I invite them to go to these sites, especially point number 3, which is run by a World Intellectual Property Organization in Geneva, Switzerland, and they offer a course called a general course on IP, a general awareness course on IP. It's very cheap, I think $5 or $10. So I request all of you to do it. Another good resource is going on point 4, which is a firm called Spicy IP, a blog. I would say one of the best blogs on this subject, very updated, latest, very well written. You will find many such case studies. You will find the latest judgments discussed here. And overall, I think your learning will really grow if you go to number 3 and 4. And I typically, what I do is I go and subscribe to the newsletters of the best law firms. I also have a newsletter myself. So I request you to subscribe to them so that on a weekly basis, monthly basis, you get a summarized, concise version of all that has happened in the world of IP, all the new developments, all the new deals, all the new commercializations. Everything is talked about in a succinct and a abridged form. So I think I would recommend that. There are, again, like I said, for patents, you might have to collaborate with somebody who's technical, somebody who's a patent agent. But for trademarks and for copyrights, I think it's something that your own office or you can pick it up, right? And the best part I always say is, because I keep going to Bangalore, Hyderabad, NCR, is the development center of most large companies, be it Amazon, Google, Hyderabad, or Meta, is in India. Most of their developments happen in India. Now, because US is on a trade war with China, you will notice a lot of manufacturing will also move to India. And the need for getting IP, the need of new brands in the food sector, in the bag sector, in the packaging sector, whichever sector, this is an area just that is poised to grow. And I, invite you to this journey. I think I've covered most of the simpler aspects. And I think the other things, as I discussed with Mr. Aman, that I will take it in a Q&A format. So yeah, happy to take your questions and happy to be connected as well. So over to CA Aman. let me know if you have any questions.
Thank you, sir, for amazing session.
Yeah.
So we have some questions. Sir, regarding old trademark, since handwritten forms are no longer accepted now, how to register online for renewal as it is neither accepting proprietor code nor agent code for registration?
I'm not too sure about that because we did a couple of renewals just recently and it went through easily. But yes, my team was telling me that there are some technical issues in the site which is causing some payments to fail and some applications to fail. But if you keep trying at a non-busy hour, I think your application should go through. One thing I would recommend is maybe try with a different trademark agent code because maybe sometimes that is an issue. I remember recently some trademarks that were filed, paid for, they were not appearing on the site because of some technical malfunction. So it happens. So, but it's not a generic case that is applying to all industry. So just try again. It should be working out.
Any other questions you can type in the chat box. Let's wait for a few minutes.
Yeah, one trend I have seen when I'm working with a lot of CAs is that in India, we do not have a concept of having multiple subject matter experts advising us. Typically, it is the CA who's the focal point of contact, and he's like a friend, philosopher, guide. After you talk business, you tend to become friends and you talk about everything under the sun. So that is where I feel this can be very good as a complementary practice. And initially, if you look at the filings also, they are rather simple. A junior associate at your firm or some person can easily be trained in this area. And overall, the kind of objections you receive for both trademarks and copyrights, again, very easily answerable. I don't find it something that is of an advanced skill. When it comes to patents and designs, I would say it is advanced. But for trademarks and copyrights, I would really request you to give a wholehearted try.
Exactly, sir.
And I mean, Aman, you can definitely share the PPT which I had used with the participants if they choose to, ask you to for it.
Awesome. Any questions or shall we continue?
I mean, like I said, I have more material just in case.
Yeah. We have around 162 participants with us.
Yeah. I'm surprised there are less questions. So I can give you some maybe interesting case studies from my examples.
Yeah, you
Uh,
continue.
So one case study I would like to give you is of Mr. Devi Shetty or Dr. Devi Shetty. I hope you have heard of his profile. Became very popular during COVID. He runs a chain of hospitals known as Narayana Rodale, and he's found out a very interesting way of making expensive surgeries cheaper. For example, a typical bypass operation or an angioplasty, which costs a few lakhs, it costs very little in his hospital, very less. That is because he's created like a assembly line model of surgery which was applied initially to cars by Henry Ford. And that assembly line model of surgery has been patented, has been registered, And now he's licensing that to other hospitals who he's charging very high amounts, $1,000 for per surgery or something. And that's how, through licensing of medical techniques, he's making rather good money. Similarly, I know of Dr. Vaidya in Pune, who used to do all these, alternative medicine techniques and was very good at his work. I think he used to see 300, 400 patients at his prime and popularity. But he refused to register anything, he refused to patent anything. And when he passed away, a lot of this skill, a lot of this practice, it sort of passed away with him. Of course, his children and a few of his students, they are still carrying on this practice, but over and above, it was completely lost. I also remember a case of a company, a pharma company based in Mumbai, in Andheri, who created a tablet because the person who created, their parents used to forget to take the tablet in the morning, evening, afternoon. So he created a tablet that you have to take in the morning, but will give effect at different times. And that was also patented. So the world of innovation, it always starts from a tragedy. It starts from war. It starts from a very niche field, and then slowly it gets democratized into masses. For example, when I was shifting recently, and one of the carpenters who came to do the work, he was using a wireless drill machine. And I was asking him, where did you get it? How can you afford this? Because I was used to seeing them using wired drill machines. And he said, sir, abhi to mil jata hai kahin pe bhi, aap easily it's available. Then I told him, do you know where this technology came from? And he was shocked to know that this technology was made for astronauts. Because in space, when you have to repair the spaceship, when you have to repair the, engine or whatever, you can't plug it in a wire and replace that. It has to be portable, it has to be wireless. So something that was created by NASA for its astronauts is now being used by the local people, the masses. Even inventions like the Jeep cars, or inventions like the inventions like Bluetooth and NFC, they were all created for military purposes, for war purposes. But today everyone has it. We are all using it very well. So I always say that the best tragedies and the biggest tragedies bring the biggest innovations, because it forces you to think, it forces you to innovate. That is why one of the best case studies that I've ever studied is the case study of Israel. Israel did not have a lot of its own food production. It was always surrounded by enemies. And overall, it was in a very precarious position, very vulnerable position. But look at Israel today. I mean, cybersecurity, intelligence, less reliance on food imports. In every area, they have been able to innovate and they have been able to master it, becoming top of the game. Today, most of their defense innovations and cybersecurity innovations are licensed to the entire world. So that's how it works. And like I said, I personally feel that now and 10 years from now, we are going to witness a lot of disruption. Smaller startups are going to enter. They are going to enter spaces where the big people have left gaps, and they're going to increase and widen those cracks. And they would want to protect their brands, they would want to protect their products, they want to protect their process in which the product was made. So this is another myth that I want to break is, when you look at a phone, you see that okay, maybe a single patent, but a phone has 300, 400 patents, right from its name to its design to its look and feel to its PCB board to its industrial design. All of them form a part of the IP. So IP does not work in isolation, it always works in combination. And today, it is also interesting to see that we have gone from a closed innovation society to an open innovation society. What is the meaning? So closed innovation means that people who have a lot of capital, like when I was growing up, people used to say Tata, Birla, that those kind of families, Rockefeller, Vanderbilt, Carnegie, all these people with lot of capital, can devote money to experimentation, can devote money to causes, and they can innovate. But today, if you see, it's open innovation. Today, I'm using a MacBook to talk to you, but I'm using a Zoom app which was built by somebody else. I'm using Microsoft Word on my MacBook. So it's all become collaborative. If you look at the Hyperloop example, which Elon Musk is trying, where you go through a vacuum tube and you cover Pune Mumbai distance in 15 minutes, how is that possible? That's possible because somebody thought of one idea, then a team from IIT Madras sent them the Dolphin pod, which is the pod that would travel. The levitation technology was brought in by Japan. So today, the world is solving problems on a world collaborative level. That's why you will see countries like US doing so well because they are able to attract the best minds from all these countries who bring their unique contribution to innovations, to problem solving, and to come out with amazing new concepts. And I don't think there has been a deal possible today without valuing, the asset separately, without getting a assignment of all these assets separately, without coming out with a. So the CA will always be asked, right? That can you assign a value to this trademark? Can you tell me how much royalty should I charge if I'm giving my brand to somebody else? So all these discussions have become popular. And that's why you will notice older brands which have gotten bankrupt are making a comeback. For example, one of my favorite bike brands called Norton, it has been bought by TVS, which is an Indian company which is doing very well. And now they're going to relaunch the brand Norton. Like Royal Enfield, also, I don't know if you remember this, is a British brand. It was bought by IHR Motors and then relaunched. And today, Royal Enfield, I think every boy at some level dreams of owning one, Royal Enfield. If you look at MG again is a British company which is Chinese owned. Jindal owns some stake. If you look at Volvo, which was a Swedish company, is now owned by China. So most people understand that brand creation, IP creation, it's a very long journey. It requires a lot of R&D talent. And if you look at the automobile sector, I personally feel Japan and Germany are fantastic. In India, we are good, but not as good. And therefore, it makes sense for Tata to buy JLR because JLR has platforms, JLR has battery tech, JLR has so many good designs. And that's why you will see now that they've started making the Range Rover cars locally, the cars have become 50, 75 lakhs cheaper. And everybody, now in my society, when I take a walk, I see so many new Range Rovers coming because now the IP has become distributed. In fact, one of my friends bought a Tata Safari because it had the same platform as used in the Range Rover Vogue. So people keep doing these kind of deals to get control over the IP, to get control over the knowledge. And I think the IP deals I have been part of, they have been, I mean, of a very good size. And therefore, I realized that whatever today the big guys are doing, tomorrow the small guys will be doing. So that's why I keep saying that 5, 7 years in the future, this is going to be very commonplace. Last example I'll give before again I pause for questions. Earlier, I remember if you want to be part of the film industry, not just as an actor, but as a writer, as a lyricist, as a music composer, whatever, it was extremely difficult. You had to know somebody, somebody would have to refer you, you had to come from a family background of film stars or whatever. Today, if you see, there are independent artists who release their music on YouTube at their own cost, at their own effort. Once the song picks up, T Series buys them, Universal approaches them, all these big guys come to them. So today it's all become that anybody who has good content, anybody who has good IP, good knowledge, good material, they will be picked up by one or the other of the platforms. So today the only goal is that whatever you have, make sure you put it in a package and you release it as long as you're protecting it. That's all. That's why a lot of my inventor friends, they are understanding this, that whenever you come out with a new concept, do not publish it anywhere. Do not put it as a part of the public domain. Keep it secretive. let first file a provisional patent. Once the number is issued, then you do whatever you want. So it's a journey where, I started when I had to create awareness. Today it's become I have to inculcate good behaviors. Tomorrow it might become easier, but that is the beauty of being in a new space, that one, it gives you that freshness, and second, you are part of those evangelists who are initially entering that field. Any other questions, Aman?
So, so
Okay. What do you
so
suggest? Do we
shall
wrap
we
up?
conclude or
Yeah, sure.
okay? So, as we come to the end of this session on IPR, I want to take the opportunity to extend my sincere gratitude to everyone who made this session a success. Kunal sir, a big thank you for being our delighted speaker, for your experience and thought-provoking perspective, even case studies at the end. I'd like to acknowledge the efforts of Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICI for conducting such an informative webinar. It's my privilege to moderate this session and to facilitate the meaningful discussions. Thank you.
Thank you. Bye.
Thank you, sir.
Yeah.